The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Friday the 13th of May 2016 are currently trading with gold at $1,272.40 an ounce, silver $17.10 an ounce, Texas crude $46.70 a barrel, and Bitcoin is currently sitting at about 457 U.S. currency. Today in history, the year 609, Pope Boniface I turns the Pantheon in Rome into a Catholic church. It was given to the Pope by the Byzantine Emperor Phocas. Pope Boniface then ordered that the church should, quote, be made to the Holy Virgin Mary and to all the martyrs, so that the commemoration of saints would take place henceforth, where not gods but demons were formerly worshipped. The rebranding of the Pantheon, today in history. In recent news, the Obama administration suggested today that public schools across the United States let transgender students use the bathroom in locker rooms that corresponds to their gender identity. The statement issued just days after the Justice Department and North Carolina mutually sued each other over their state law requiring transgender individuals to use a public bathroom that corresponds to the gender on their birth certificate. And though this push from the White House is not legally binding, since this issue has not yet been definitively answered by the courts, schools that refuse to comply could potentially be hit with a civil rights lawsuit from the government and even face a cutoff of federal aid to education. Texas's Lieutenant Governor Republican Dan Patrick said that the state is prepared to forfeit billions rather than to let the Obama administration dictate restroom policy for its 5.2 million students. Many other governors and state legislators have voiced similar concerns, calling this a blatant overreach of executive powers. At BMW's annual shareholder meeting yesterday, BMW chairman of the board, Harold Kruger, detailed BMW's next innovative flagship, iNext, an autonomous, intelligent, lightweight electric car, a combination of BMW's electrified i brand and the Vision Next 100 concept car that debuted with the company's 100th year birthday. This sci-fi ride will be BMW's answer to the growing number of high-tech luxurious electric vehicles, running up as the major challenger to Tesla. The Lone Star Lowdown is currently looking for sponsors. If you have a product or service you'd like to advertise with us, feel free to give me a call at 210-363-2257. It's been Rick Rohde with your Lowdown for May 13th, 2016.
Welcome back to Rule of Law Radio with Randy Kelton and Yvette Peck. We are about to bring on Irvin, I hope I'm saying that correctly, from Nevada.
Yes,
Randy, can you unmute?
I got him unmuted. Hello, Irvin.
Hi, Randy. I was last on the show two weeks ago. Can you hear me?
Yes.
Yeah, okay. Yeah, you were kind enough to give me the email address. I sent a couple of questions. I hadn't heard back, but one thing I touched upon in the email was like theoretical thing. A fellow I've been listening to takes the stance that deed of trust state foreclosures are not really constitutional. He says that the personal rights, life, liberty, and property cannot be taken from you without due process of law, which means adjudication in the court of competent jurisdiction, and would be a violation of the Federal Constitutional Amendments 5 and 14, and that the promissory note and the deed of trust are something called the chosen acts, and they can only be executed after a court order. So he's preparing
she's missing something really important.
Deed of trust. Sorry?
What she's going to is your property can only be taken from you by a unrelated party through due process of law. For instance, you cause a tort, like you have an accident, run into somebody and hurt them real bad, and you don't have enough insurance to cover it. Then they can potentially take your property from you, but they have to do it through due process of law. They have to file suit, get a judgment in the suit, and then get a claim in the suit and a judgment against your property. But you can enter into a contract to pretty much do whatever with your property you want to. And that deed of trust is a contract that you voluntarily entered into. And part of the contract was the grant of a claim against the property and the grant of a confessed judgment in a non-judicial state. So you're not under tort law, you're under contract law. Does that make sense?
I think I'm following you. Yeah, but you're saying that that's not a viable argument because that's only an individual who can't do it.
That argument would only fly if the two people were not engaged in a contract.
I see. Okay, that was a theoretical part. Now, the one which affects me is I mentioned to you, I owned a house in Virginia, deed of trust state, and first of all, there were no payments on it made since September of 2008. So, amongst other things, it's my understanding that's past the statute of limitations for the state of Virginia and maybe for the...
Okay, no, hold on. One caveat. The statute of limitations is not triggered by non-payment.
No.
The statute of limitations is triggered by a notice of acceleration.
Which was done in early 2009. Yeah.
Okay.
So
that's the date they filed that. That's the date the clock starts. So do they have 4 or 6 years?
Six. So even at 2009, January 7th. So there's that. But anyway, and eventually the house, which has been rented for years, was vacated and trashed, and they applied for a notice of foreclosure. It only gave 3 weeks. And in Virginia, they say that even though it says 30 days in the deed of trust, that they don't have to abide by that. So that might be something to be contested too. But
wait, hold on. The deed of trust says 30 days.
Yeah.
Then yeah, they do. That's the contract. The contract stands before the law. Contract first, law second.
I see. Okay. They didn't inform me of...
You can mutually agree to 2 days.
Right.
Contract.
It has to be mutual. Right. I see. Okay. The thing is, they didn't inform me of the alleged change of trustee until that same 3 weeks before. I thought they had to give you more time than that. I couldn't definitively find that, but I don't know what your thoughts are on that. And last but not least, I had done a rescission, which they ignored for the 20 days, and I recorded a notice of interest in real property in the county showing the rescission letter, the certified mail stuff, and an affidavit from me.
In the rescission letter, what did you... Okay, this rescission letter was filed after the notice of acceleration. So in order for that to be valid, you had to claim an accounting error of over $35.
Yeah, I did. Yeah.
Good. Okay, that was in there. Perfect. Okay, then you have some good claims.
Okay. Well, they also, let's see, although the foreclosure was supposedly done February 18th, when I last spoke with you 2 weeks ago, they had not changed the name in the county records. You were mentioning filing a mechanic fee with a disinterested third party, but that following Monday.
Okay, hold on. That tactic will only work if they actually did foreclose. Did they come to you and offer a loan modification?
No.
They're required to.
Well, they didn't.
And see what they may be working through to make sure they got all their ducks in a row. And almost certainly, most of the time when they file a notice of intent to foreclose and give you a date, they almost never sell on that date.
Yeah.
On rare occasions they do, but almost never.
Right.
And
they switched it officially to the lender's name, Bank of America, the following Monday, 2 Mondays ago. And again, that thing is recorded in the county recorder, so I thought, bad faith, unclean hands, or something of that nature. But as far as claims for trying to do a wrongful foreclosure suit, off the top of your head, with the limited information I've given you, whatever.
Oh, no, this is. I suggest that you don't start with a wrongful foreclosure suit. Again, we're playing chess here. You go back and file a quiet title on the deed of trust based on rescission.
Oh, well, that brings up yet one more problem, though, since you mentioned that. I have that right here. And a book which, on quiet title, I don't know if you're familiar with Dave Krieger, but he's a lot of experience with that. He mentions... Yeah,
Dave thinks I'm still in jail.
Okay, I didn't know that part. But if I may, just these a few paragraphs he mentions for an attorney who actually won a quiet title case was expected to be vacated. Here it is. He says, in talking to Virginia attorney Greg Burrell, he mentioned that because the state's courts operate off of common law, obtaining a firm quiet title judgment will be extremely difficult. He managed to get a quiet title judgment for a couple in Fairfax County, Virginia, but fears that U.S. Bank will come in and get the deed of trust reinstated. As Virginia does not condone removal of deeds of trust or other instruments from the land records, they just rule whether they're void or not. This would appear to indicate that a direct attack on the note would have to occur utilizing the UCC, which in and of itself also appears difficult, given Virginia courts' rulings that deeds of trust are merely evidence of a promissory note. There is no requirement for assignments or any other relative instruments to be recorded in the county land record. See, blah, 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 is the case here. Noting that the assigner was, quote, not required to obtain the consent of anyone, unquote, when the subject contract included a clause specifying free assignability, cited in blah, blah, blah. While the majority of legal...
There would be one question I would ask of Krieger. The fact that no one is required to file, that's pretty consistent across all the states. But Texas has a statute, and every state I've looked at has a similar statute that says any claim against real property not properly acknowledged or proven and filed in the public record is void as to the holder. So while he's correct, you're not required to file anything. If you don't, then you can't adjudicate your claim. And without that statute, there is no reason to have a county recorder.
Oh,
so
well.
I'm almost certain you're going to have that statute. So they're missing a point. You know, what I say is I look in the record and I want to see a clean chain of title.
Uh-huh.
And I've got one right now where JP Morgan Chase has nothing to do with anything. And all of a sudden they put in a notice of lost assignment. Oh, we got this secure vault in Monroe, Louisiana, and I looked all through it and I couldn't find the assignment. And he files a notice of lost assignment. And then he files an assignment to somebody else. And I'm saying, well, if you lost the assignment and you didn't get it filed in the record, you can use it for toilet paper. Yeah, I don't care who owns what. If it's not filed in the record, you can't adjudicate your claim. Because I have a right to trust what I see in the record. If you want to sell me your property, I need to make sure there's no claims against it. So I go look in the public record. If I don't find any there, then I have a right to trust what I see there. I buy your property, somebody else comes with this claim. Sorry, Bubba, you should have had that in the record. Or I could see it before I purchased this property. You see why that's so important. The Pilgrims set up a registry in 1635 or 1653. When they first came here and started divvying up property, they set up a registry for that purpose. So while it may not be required, isn't Plymouth in Virginia?
Well, you know what else is in Virginia? Mers and Reston. And you of all people, that's how I first discovered you.
I mean, isn't Plymouth Rock in Virginia?
No, I don't think so. No.
Okay, anyway, it's close. But, you know, that's been a primary requirement so that we could buy and sell property with confidence. You're going to have that statute. So they missed that part.
Right.
Well, you may have your assignments and claims. You can change them all you want to, but if you don't file them in the record, you can't come and adjudicate them.
Yeah, but
that's my story, and I'm sticking to it.
MERS came in a year and a half after a guy got the quiet title adjudicated in favor of the homeowner, a year and a half, and sued. They weren't noticed and had the gall to sue, say that the California Constitution, it was against their rights because they were noticed. They were denied due process. So MERS, you know, they seem to be able to do whatever they want to.
Now, wait a minute. Okay, what was MERS? How did they have anything to do with anything?
Oh, no, I'm just saying, in general, when you say that, what you said makes perfect sense to me. But as an example of an exception to that, MERS in some states, they're given free reign to come in, as I said in that case, and a year and a half after the guy only sued the only people on the land records. And MERS came in a year and a half later and got the judge to do a reversal.
Well, we have problems with them not following rules and following law. But Vet, you want to take us out? We're about to go to break. We lost Vet. This is Randy Kelton, Vet Pack, Real Law Radio. I called him number 512-646-1984. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let them get to you. Only the Father can deliver you. So don't let bad mind people hurt you.
You're listening to Rule of Law Radio. This is Randy Kilton and Yvette Pack. We are speaking with Arvin. Would you like to finish?
Yes. The last part of that quote I read, can you hear me?
Yes.
Yeah, I can hear you.
Yes, I'm sorry. That Attorney Burrell considers, while the majority of the legal community considers Virginia to be a title theory state, Attorney Burrell considers it a lien theory state, given the propensity as to how note issues are treated by the courts. This would appear to make declaratory judgment and quiet title causes a true uphill battle, as Burrell thinks his quiet title action will be vacated because of the attitude of the courts. So that gives one pause for thought. I think you mentioned trying to do a quiet title to attack the trustee sale now that it's finally official.
Okay. I think part of the issue here is why we're going to court. Most of these guys, David Krieger works with a lot of lawyers, and lawyers want to make sure they can win their case. I don't care. I know this. You're not supposed to do this, but I'm going to cost the bank as much money as I can. And by shooting at them with a quiet title issue, I want to find the most innocuous claim I can make and hit them with that first. I've got a friend that I'm working with in California, and this was about 6 years ago. I went out there and did a seminar, and he went with me, he said, because I was the only one that got in there and said, if anybody comes in here and promises you they can give you a particular result, don't walk away from them, run away from them. Because the courts are corrupt. You never know what they're going to do. So first thing we did was filed essentially my nonsense suit. And the suit said, who are you? I don't know who you are. I never entered into a contract with you. I never entered into a contract with your alleged principal. Prove up your position. That's it. 6 years ago. We are before the Court of Appeals right now. They had to wait for us to give them a letter brief on the effect of the Inova decision. Almost certainly the bank's case is going to get thrown out of court.
So,
the judge ruled in their favor. The appeals court's been forced by the Supreme to throw it out. This is 6 years. And that was my garbage suit. I didn't even get to the good stuff yet. So generally now when I take on one of these issues, I always want to make a deal. It doesn't make any difference what the law is. It doesn't make any difference what your position is. The courts are just corrupt. They are going to rule against you out of hand at every turn. Just expect it. That's not necessarily a problem. I can live with that. Because I can keep these guys in court till they get old. You lease your property out and hit them with a quiet title, lease your property out, and you're going to go back and forth on the quiet title and then go pick out one of their assignments and go after the assignment and then go after MERS, buy the contract. What is MERS? If you read the contract from the least sophisticated consumer perspective, MERS is a nominee for the lender. Okay. In the deed of trust, I nominated MERS to be an agent for the lender. But I didn't appoint MERS to be an agent for the lender. I mean, what would the lender say if I said, okay, I don't like MERS. I don't want to nominate MERS. I want to nominate my brother-in-law. I want him to be the beneficiary and the nominee for the lender. Well, if the nominee is their agent, they're not going to go for that. So I'm not appointing MERS. I'm nominating MERS. Now show me where you appointed MERS. Because you certainly don't get it from the deed of trust.
Right.
And MERS is the beneficiary according to the deed of trust. Okay. In my deed of trust, I defined MERS as the beneficiary. So I gave all of your beneficial interest to MERS and you accepted the contract. So when MERS does an assignment from you to somebody else, he transferred the beneficial interest that you had or he transferred the interest you had in the mortgage to somebody else. And that interest was none because MERS has got it. It says so in the contract. I didn't write that contract. They did. So apparently they wanted MERS to hold the beneficial interest. But then again, you get down a second actual paragraph of the contract itself. It says you understand that MERS is not the beneficiary, but merely holds legal title. No, wait a minute. I thought the trustee held legal title. So I transferred the beneficial interest to MERS, but halfway down, MERS throws away the beneficial interest, and now he takes legal title away from the trustee. This contract is too ambiguous to be enforceable. When considered from the least sophisticated consumer perspective, I think whoever wrote that contract was high on coke. Well, read it. It don't make any sense.
Yeah.
I mean, who wrote this nonsense?
You don't have any skin in the game, and you're not entitled to any payments. That's another thing, right?
Yeah. So you take them on that. You sue them, claiming that the deed of trust is too ambiguous to be enforceable. You keep them in court for 5 years on that one. And when you get done with that one, you got something else you can throw at them. So lease the property out, collect the money on it, and you get paid for being your own lawyer.
Right.
And in the meantime, you go to the other side. And I suggest you do this on the first day. Well, last quiet title I filed, the lawyer contacted me, let me know he was representing the bank. And I said, look, don't even answer the suit. He said, well, if you don't want me to answer it, why did you file it? Well, I couldn't figure out who to talk to. The only way I can find somebody to talk to is to sue them. And he said, well, that makes sense. I said, tell you what, if you'll agree to negotiate a settlement on this contract, I'll non-suit that thing. And he said, well, yeah, if you non-suit it, you could refile it at any time. I said, yeah, I could, but I didn't want to file it in the first place. I wanted us to make a deal. I want you to knock off all these stupid fines and attorney fees and all that nonsense and decrease the payoff amount by half of what I'm going to cost you in attorney fees, and let's renegotiate this note. Otherwise, I'm going to keep you in court till you get old, and I'll just lease the property out, and I'll be making money the whole time. So do whatever you want to do. Then when they don't negotiate in good faith, then you send a letter to the court asking the court, or a motion to the court, asking the court to order mediation. So you're telling the court, I'm trying to settle this thing. These guys are being recalcitrant. They're forcing it to stay in your court. I'm not in here because I want to be. I'm here because those guys are jerks. And then now you have a claim that you're not a vexatious litigant. You're trying to settle this thing, and they're not settling. And you just lease it out until they settle. Everything you do, every motion you file, you ask them to settle every time. It's the only way you're going to win. You can win with a settlement. You're not going to win in court. Look at Leslie. Leslie does incredible, impeccable motions and pleadings. She's got them every way they turn, and still they don't care. They bought these judges. The judges are absolutely bought and paid for. They think they're absolutely immune, and they're going to rule against you. Okay, maybe they won't, but it behooves you to conduct yourself as if they will. The only way you're going to get to a win at the end of the day. Does that make sense?
Yes, it does. Okay, then. Thank you very much for your document and the information. I appreciate it.
You are most welcome. And I see Tommy there. We'll pick you up on the other side. We're about to go to break. Vet?
Yes.
Stop.
Sure. This is Rule of Law Radio. You're listening to Randy Kelton and Yvette Pack. Call us at 512-646-1984. We'll be right back.
We all know smoking is bad, but new evidence shows babies whose fathers smoked around the time of their conception have an increased risk of developing childhood cancer. I'm Dr. Catherine Albrecht, back with details in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Smoking kills. It's no secret, and we've all heard the health warnings. But did you know that tobacco could also kill your unborn child? Australian researchers found that although mothers smoking did not increase their children's risk of getting cancer, kids whose fathers smoked around the time of their conception were more likely to develop acute lymphoblastic leukemia, or ALL, the most common form of childhood cancer. And the more dad smoked, the greater the risk. If dad smoked a pack a day, his baby was 44% more likely to be diagnosed with the disease. So papas, consider what you're doing to your unborn kid before you light up. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
We are back. You are listening to Rule of Law Radio with Randy Kelton and Yvette Pack. We are about to bring on Tommy, I believe. Randy, did you bring him on?
Hello.
Hi, Tommy.
Can you hear me?
Yes.
Hey, thanks for taking my call. Hey, I had an exciting day at the Precinct 2 Justice Court in Cherokee County on my initial appearance for a alleged speeding violation, a traffic citation. Now, leading up to this day, I had several contacts with the court requesting case file information, specifically a copy of the ticket and a copy of the verified complaint. They continuously refused to give me access to my file or give me a copy of the information I requested. And the judge went so far as to send me a letter saying that my case has been forwarded to the county attorney and any further correspondence will be directed towards him, and basically don't contact them anymore. But I was still required to appear today. In fact, the county attorney told me that as much. So I show up today, and I go there with my documents to file my motions, and he says, yes, are you here to plea? I said, no, I need to file these motions. He says, you can't file any motions until you plea. I said, no, that's not true. So he calls the county attorney. And the county attorney, through him, is saying, I have to make a plea. If I want to see any court documents, I've got to go up to the county attorney's office, or they'll show them to me at pre-trial. And then he tries to hand the phone to me. Here, he wants to talk to you. I said, I'm not talking to the county attorney. I don't need to talk to him. I'm going to file these motions. And then he said, are you filming me? I said, I am videotaping this, yes. I don't approve of that. I said, well, I'm sorry. I said, this is a public place, and you're a public servant, and I will video this. And so he ends up, the county attorney told him, go ahead and take his motions. And so after I filed the motions, he said, anything else? I said, yes, I need to inspect the case file. He says, he calls the county attorney again. He says, no, the county attorney says you can see it at pre-trial. You can go up to the county courthouse in Rusk, Texas, and look at your file. I said, okay, wait right there. I'll be right back. I went and secured all my notes and stuff in my car. I called 911 to have the police come up there. And so the judge is hearing me say all this to call 911. He said, are you calling the police? And then he calls the county attorney back. He's calling the police on me. What do we do?
Oh, my gosh.
And so the policeman gets there, and he's maybe 30 at the most. He's really young. And he walks in, and he says, what's the problem? I said, pointing to the judge, I said, I need you to arrest this man. He says, what for? I said, he's committing a crime. And I had my Texas statutes book there, and I had everything lined up for the penal code, and I pointed to him exactly what he was doing, and the judge, again, in his presence, denied me access to the file. He says, well, I don't think I can arrest him. I said, okay, well, get your supervisor down here. He says, I'm the only supervisor you're going to get today. I said, are you a supervisor? He says, no. I said, well, get your supervisor. Well, he's not here today. Well, then call the police department and get whatever supervisor is available, bring them down here. Well, by that time, now the judge, he's still back on the phone with the county attorney again, wanting to know what to do, and then he calls the sheriff's department. So now, and then I guess somebody at the police department said, no, it's a county matter. Let the county handle it. So the sheriff shows up, the sheriff's deputy shows up, and he goes and talks to the judge out of my hearing, and he comes back and says, look, Mr. Hargraves, I understand what you're trying to do, but the judge has spoken to the county attorney, and if you want to, and he's instructed him that if you want to see those files, you need to go up to the county courthouse to see those files. And about that time, the constable had showed up. He comes out there and he says, just a minute. He hands in this little form to the sheriff's deputy. He says, the judge has instructed you to file a criminal trespass warning with Mr. Hargraves. He says, okay. He says, no, Mr. Hargraves.
Wonderful.
He says, this doesn't mean
that's.
He says, yeah. He says, it's not a ticket or a citation. It's not going to be on any record. We're just going to keep it at the sheriff's department. And I said, look, I don't know why. I said, I was never instructed to leave by this judge. In fact, I'm ordered to be here. I had made a promise to appear. The county attorney told me I need to be here. And he said, yeah, but you filed your files, and the county attorney has now instructed that if you want to see any other case files, you need to go see him. I said, okay, that's fine. And so he issues me this criminal trespass warning. And
are you familiar with 36.06 Texas Penal Code?
Is that the one that talks about criminal trespass?
No, that's obstruction retaliation.
That's what I knew there was something wonky about what that judge was doing, but this is the best news of the whole day. Listen to this.
So now you prepare felony retaliation against the judge. He retaliated against you for the purpose of preventing you from exercising your right, and because you called 911 on him.
Exactly. And so I'm barred from that courthouse for at least a year. And as I'm walking away with the sheriff's deputies walking with me back to my car, he says, I want to ask you something, and you don't have to answer if you don't want to, but I'd like to ask you, do you know Randall Kelton? I said, yeah, he's a friend of mine. He says, well, tell him Deputy McClure says hello.
Oh my goodness, Deputy McClure. That is wonderful. Deputy McClure was the bailiff when I was prosecuted down there, and he was so disgusted that he quit being the bailiff and went to the jail as a jail guard.
Well, he said, Randy opened my eyes. He shared with me many interesting things and opened my eyes to some things. He says, you make sure you tell him I said hi. You make sure you tell him.
Wonderful.
And he says, look, I understand what you're trying to do, Mr. Hargraves. He says, my hands are tied. He says, I'm caught in a crossfire here. I'm being instructed by the judge to do this. He says, I don't know what else to tell you. I'm sorry. This is what I have to do. So I said, I'm not upset.
You absolutely got the best sheriff's deputy in Cherokee County.
That's what I feel like. Yeah. In fact, he even called me back afterward after I left, said, hey, Mr. Hargrave, just want to thank you for being professional and courteous. And my hands were tied. And don't you forget to tell Randall Kelton I said hi.
Well, that is good to hear. I need to contact him because I really did like that guy. He's actually one of us because he really was a good guy.
So he played fairly neutral, but he gave me the hint that I understand what's going on here. So I think he recognized your thumbprint there on the whole situation, and he said, "You know Randall Kelton."
Oh yeah. I kind of put him on the dime a time or two. I asked him to arrest the judge a couple of times. Yeah, Mr. Kelton, you know I can't arrest a judge. I said, come on, Deputy McClure, take your chicken suit off. I said, this will be fun. No, it won't be fun.
Well, he admits, and I've got the video of the judge talking to the assistant county attorney, instructing him. I mean, isn't that some type of conspiracy right there to deprive me of my entitlement to review these documents?
No, but that is interesting. They may have screwed up big time. Hang on, we're about to go to break. You want to bring us out, Matt?
Sure. You're listening to Rule of Law Radio. This is Randy Kelton and Yvette Pack. You can call us at 512-646-1984. Easy.
For. When I'm hungry, I like to know just what I'm fishing for. I ain't asking for much.
You're listening to Rule of Law Radio. This is Randy Kelton, Vet Pack. We are talking with Tommy out of Texas. Tommy, did you have anything else to say?
Yeah, I really think that this is the first time this judge has been, has seen something like this, because he, I don't like to disparage judges, but he seemed incompetent, because while he was on the phone with the county attorney asking if I was going to plea, and I said, well, I can't plea until I see a proper charging instrument. And he holds up the ticket. He says, this is a proper charging instrument. I said, no, it's not. And he says to the county attorney, he says it's not a proper charging instrument.
Okay, here's what's happening. In this case, The prosecutor is not acting as a prosecuting attorney. He's giving legal advice to the judge. Let me tell you a little story about legal advice. I tried to file a complaint against a nephew-in-law who is estranged from my niece, and he's acting ignorant. So I filed a complaint against him to get them to kind of calm him down, to keep him from doing anything stupid. And the policeman, the chief of police of the town I live in, tried to do what he does all the time and decide which complaints he'll act on, which ones he wants. So he doesn't give it to some magistrate. And I come back and challenge him about it. And he said, well, I talked to the prosecuting attorney, and he said that I shouldn't pursue. I said, okay, I'll go see James. James Staten is our county attorney. So I go down and I go up front. And I told the secretary there that I need to talk to James. I said, can I tell him what it's about? I said, yeah, I'm about to land on him like a ton of bricks. One moment, James comes out, and he already knew all about it. He said, Mr. Kelton, do you think I am out of my professional mind? Do you really think I would waive my sovereign immunity by giving legal advice to the police? I said, well, I didn't think so, James, but I'm just following the thunder here. He said, well, I didn't advise him to do anything. Okay. So I go back to the police department. I knock on the door. This officer comes to the door. Well, hello, Mr. Kelton. What can I do for you? I said, well, James Staten, the county attorney, just threw your chief under the bus, and I'm here to run over him with it. Hey, he just laughed. Come on in, Mr. Kelton. But point is, when that county attorney was giving the judge legal advice, he wasn't a county attorney. No immunity.
Oh, wow.
Judicial conduct and bar grieving. I'm sorry, I said judicial conduct. Bar grieving and malpractice suit.
Okay. Yeah, and in fact, the sheriff's deputy reiterated specifically that information.
Oh, that's wonderful.
Yeah.
They will not see this one coming. So They don't know what to do. They literally have no clue. Was this a justice of the peace?
Yes.
Oh, perfect. That's why he called the county attorney.
Right.
So in this case, the county attorney, they weren't in court, so they were not adjudicating a case. The judge clearly called the attorney for legal advice, and the attorney gave him legal advice, and you can construe that the attorney directed the judge to bring up the criminal trespass. Wonderful. Now you get to sue the lawyer. You need to prepare a tort letter and send it to the county commissioners accusing the county attorney of malpractice by giving false and fraudulent legal advice to the justice of the peace. Okay. Immunity is based on the claim that you make, not whether you can prove it or not. But if you make a claim that the lawyer gave legal advice and you're suing him based on the legal advice, no immunity. Now, he can claim he was adjudicating a case, but access to records is not part of the adjudication of the case. So they won't see this coming. And you will enjoy this. You will find that they treat you much differently, especially if you file against the judge for felony retaliation.
Because it did seem retaliatory, because I was never one. And plus, it's a public place. I mean, it's paid for by the people. The judge doesn't own it. He doesn't have ownership of this building.
Oh, you gotta love it when they act really stupid. And it's my rule: never interfere with someone when they're screwing up. And if you kept your cool, okay. For everybody else who's listening, how hard was it for you not to get upset?
It's kind of hard for me. I hate injustice, but I kept my cool because I kept thinking, okay, this is how it's supposed to be. I shouldn't be upset.
Perfect.
This is what
that is perfect. And look what happens to them. They're used to getting people jumping up and down and railing in righteous indignation, and then they accuse them of being agitated. If they can't get you agitated, then they get agitated. And when you write up the complaint against the judge, you should accuse the judge of being agitated. They are going to hate that because that's their term.
Now, am I going to be going to the district attorney with this? Because I think the county attorney, or the county judge will be.
I think you need to take this directly to the grand jury, or don't take it, send it. Certified mail, district attorney's office, grand jury foreman, care of the district attorney's office. Now, I have made a really big stink down there over that. So it'll be interesting to see what the new district attorney does. She was the assistant district attorney when all this came down.
Oh, so she'll know what's going on.
Yeah, she'll know what's going on. And she's not likely to want this to come up again. But if you're concerned about Cherokee County, you can take it to another county.
Yeah, well, they seem all pretty tight there. Good old boy network, all nice and snuggled in.
We take it. Try Cherokee County. Take it to, send it to them and see what they do about it. Yeah, and they'll know you're setting them up.
Just a criminal complaint, a separate criminal complaint for the judge and one for the assistant prosecutor.
Yeah, the assistant prosecutor for conspiring to retaliate against you. The judge conspired with the prosecutor to retaliate against you.
Okay.
The best part of this is not what you can prove, just enough to make the accusation. That's all you need.
Right.
And then if you get any feedback from the district attorney, I'll write you up. I already have a statement addressing the fact that the prosecuting attorney has no discretion in the matter of a complaint against a public official. He must give it to the grand jury.
Okay.
And you can also take it to the Texas Ranger. Send one to him, certified mail. And when he doesn't give it to the grand jury, then you get to file against him. That's what I just did in Wise County. I filed against the ranger because he gave my complaint against the district judge to the prosecuting attorney. Accused him of conspiring to obstruct justice. And he was following protocol. That's the best ones to file. If they're following flawed protocols, then you charge them for it. And let him say, oh, I didn't know that was illegal. Sure, good luck on that, Bubba. You are screwed. You followed a flawed policy in order to keep your job. So as a result, you're subject to criminal prosecution. Life is filled with little decisions, and you got to make one. You just made the wrong one. So does it sound like fun?
Yes, sir.
You'll get on a list. You'll see an officer pull in behind you, run your plates, pull around you, and get lost.
Well, that may be the way it ends up in Cherokee County. I don't know, because they're starting to know who I am.
Once they know you'll come after them, that you'll give them a fight, they don't want to fight. They don't want anything to do with it. I had a sheriff's deputy come to me and ask me what I did to the sheriff. I said, well, I haven't done anything to him lately. Why? And he said, well, we had roll call this morning, and he asked who here knew Randy Kelton. About half of them raised their hand. He said, look, you are not to stop him. You are not to cite him, and whatever you do, don't put that SOB in my jail. What? I only sued him a couple of times.
Thanks, Randy. Hey, I will let you get to the next caller. I appreciate it, and I will be back in touch with you on this matter.
Okay, thanks, and that was really good news. I'm glad to hear that you got their attention. Okay, when we come back, we're going to go to Joseph in New York. Yvette, you want to take us out?
You got it. This is Rule of Law Radio. Call us at 512-646-1984. You're listening to Randy Kelton and Yvette Pack.
This is where I issue a random insult to somebody.
Story for everyone to hear about how we're not gonna give in to the fear. Yeah, it's a story. I will hide by my father's house until he returns.
Okay, we are back. Randy Kelton, Yvette Pack, Rule of Law Radio, and we're going to Joseph in New York. Hello, Joe. What do you have for us today?
Well, I wanted to update you on my case, as I promised. I went to court on Tuesday, and it took the judge a minute and a half to recuse himself.
Why so long?
I don't know. Well, he wanted to find out whether or not I'd been foolish enough to, acquire an attorney as he had suggested. Like, no, I don't think so. That's 2 judges in a row now.
Okay, so why did he recuse himself?
Because I told him to. I mean, I suspect that's what I submitted some peremptory challenges and pleadings and described, all the different reasons why he needed to recuse himself, and he appears to have followed my advice.
Well, that's interesting.
That's my best guess.
I have noticed about New York, I think if there is any state where the judges tend to take the law serious, it's New York. I had a friend, Chris Campanelli, several years ago. He filed a complaint against the sheriff and a city council member. Or no, I think it might have been the sheriff and the mayor. And they both wound up getting the state police actually come and arrested both of them over his complaint.
Wow.
And I saw a case on a judicial misconduct issue where they sanctioned a judge. And they sanctioned the judge because a case sat on his docket for more than 180 days, and he didn't clear the case off his docket. Mm-hmm. They sanctioned him for failing to maintain his docket. What in the world? Holy mackerel. So you may actually have some functional oversight in New York. Because, New York is the only state that I've seen where if someone is arrested, they're taken to a magistrate. I use as an example the comedy Night Court. It was set in New York. It was set in New York City, and it was a court that went at night because if somebody's arrested at night, then they hold them just long enough to appoint an attorney for the purpose of this hearing, and then the accused and his attorney comes before the court. The officer and the prosecutor come before the court. And both make their case, and the judge decides whether or not the person has to stand and answer. Now, while Night Court was a comedy, constitutionally, it was dead on. And the last time I was in New York City, I went to a court and observed, and they were doing just exactly that. So, Joseph, you may be in the best state to actually adjudicate your rights. And the fact that the judge took your pleading seriously is very encouraging.
Well, I did file a judicial conduct complaint on him, for what he'd done previously. I found out that he was not licensed to practice law in New York State, and, he was practicing law from the bench, so I turned him in for that.
Wow.
Sounds like he was glad to be rid of you.
Well, he ruled that the court acquired jurisdiction. When Jacqueline, the deputy prosecutor, I made a motion to dismiss on the grounds that a traffic ticket is just an invitation to court. It doesn't confer jurisdiction in any way. And I got this deputy prosecutor who's supposed to be an authority in vehicle traffic law and civil, criminal procedure. Writing up this response, that affirmation and response stating that it is, completely ridiculous. So when I attacked that, he just, granted her motion. It's like, well, the statutes say otherwise, and all the case law says otherwise, and you're deemed to know the law. So what the hell do you think you're doing? So I did that. Let's see. I read some. Let's see what the heck else I go after him with. Yeah, I requested a copy of the accusatory instrument. They refused to give it to me. He told me that they weren't required to give me one until trial, until the trial date was set. So I put that in there. He willfully committed abuse of discretion denied my request for a preliminary motion or probable cause hearing. And upon my challenge to the court's authority to hear a matter for one of court's cause, he said I was allowed two options. The first being compelled acceptance of a court attorney, the second being the setting of a trial date. And because I refused to plea because, there was no cause, he threatened me with competency hearing, for making an active defense.
Have you looked up the retaliation statute in New York?
No, I haven't. No.
That can be construed as retaliating against you specifically because you vigorously adjudicated your rights. Texas, that's a felony.
Retaliation statute. Okay, good. I write that down. So I did that. Then I bar-grieved the deputy prosecutor because she sat at the table behind me for two of the hearings and just allowed the judge to adjudicate her case or her non-case, her claim, I guess, whatever you want to call it. So I hit her for misprision of felony and a bunch of other stuff. Bring it up. Let's see. Yeah, she submitted an affirmation in opposition, which is, of course, a violation of Trinzi v. Pagliaro. The affirmation stands as prima facie evidence of official misconduct because the affirmation claimed jurisdiction is conferred by the simplified traffic information in clear and irrefutable opposition to CPL Part 1, Title D, 7010, Part 2, Title H, 100.5, 100.10, 100.15, 1 and 3, 140, 1 and 2, 150.50, 1 and 2, and 170.10.2, and Title I, 200.50. I mean, she's, deemed to know the law. And then, I put down a bunch of case law here where, this fact is fully supported by precedent in the doctrine of stare decisis. Let's see, what else did I get her for? Okay. As a member of the bar who specializes in the prosecution of vehicle and traffic law, she is deemed to know criminal procedure law. She further contends the jurisdiction attached to when she failed to even invoke the jurisdiction to challenge. She further contended in her affirmation that I was not prohibited from defending myself when the court compelled me to do so. The court attempted to compel me to plea and disregarded my assertion of my right to preemptive defenses, protections, and immunities, and to make preemptory challenges and dilatory pleas. The court entered a plea of not guilty against my protestation, subjecting me to the rules of general appearance, which would have the effect of waiving my right to any further preemptory challenges or dilatory pleas, such as non-assumption or estoppel. The court refused to provide me with a copy of the accusatory instrument, declaring the appearance fixes were sufficient. And she failed, of course, to attend that initial arraignment. And I was clear. I made sure I asked the judge, "Is this an arraignment?" And he declared it is, and I did get a copy of the proceedings.
Okay. You also said that you did not get a probable cause hearing.
No, they refused to give it. Both.
Have you challenged subject matter jurisdiction?
Yes.
Oh, good.
Throughout, from the very first hearing, I've been to 4 hearings now. I've challenged subject matter jurisdiction all along, and I filed, motions to dismiss and also judicial notices. There's no subject matter jurisdiction here.
Did they hear your challenge to subject matter jurisdiction?
Have they heard it?
Yeah. Did they have a hearing on it?
No.
Ooh, my. You mentioned a general appearance. You're there at arm's length to the court. You're there by special appearance.
Exactly, and and Judge Petrucci just said, "Well, I'm entering a plea of not guilty, whether you like it or not." Both judges said that, but Judge Knight backed off. I hit him with a motion to dismiss and a quo warranto, and then he responded that he didn't actually write it into the record, and he was not going to. He changed his mind on that, and then he denied my motion to dismiss and granted her affirmation.
Okay, have you filed any criminal charges against the judge or prosecutor?
presently doing that now. I brought up in our AG's office, they have different bureaus. And so actually, we're talking some violations of, what is it, Clayton and Sherman antitrust. So I've got a antitrust violation. I've got they've got a special bureau for when public officers are misusing their office. So I've got to file with that bureau. Then they have a financial crimes bureau and a civil rights bureau. I was going to file with all of them, and then let each one know that I served on what I gave to the other, so they don't work independently.
Have you filed with? Hang on, we're about to go to break. Yvette, you want to take us out?
Sure. You're listening to Rule of Law Radio with Randy Kelton, Yvette Pack. Please call us at 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Oh, come on.
You're listening to Rule of Law Radio with Randy Kelton, Yvette Pack.
And we're talking to Joseph in New York. Okay, Joseph. It's one thing I'm thinking. There is an avenue that we generally don't think to take. And you were talking about all these different bureaus New York has set up to handle these different kinds of issues. But I'm always dubious of government officials when they are monitoring other government officials. And
yes.
I come to the table from the perspective that they are all public servants. You and I, we are the masters. And the master doesn't start at the bottom. Several years ago, New York revamped its grand jury system. You have a very good grand jury system in New York. I suggest you go to the grand jury and let the grand jury send this down to those bureaus. It'll come down with a lot more authority.
Okay.
It's because you're the CEO.
Concept to me. I mean, I've heard you talk about it, but I haven't.
Okay, let me talk about that a little bit. And this is how it is in Texas, and I'm going to assure you it's the same in New York. A long time ago, when there weren't so many people, we had district judges, and all the district judges were circuit judges. They were statewide judges. You call them a little different in New York because Supreme Court in New York is the lowest court. I never get used to that.
Yeah.
But your felony judges, the judges handle felony cases, they're statewide judges. And they used to ride a circuit. And then we got enough people that we got more judges, and they gave each of the district judges a venue. They restricted them to a specific venue. And it is a district judge that impanels a grand jury. However, while the district judge has a statutory venue restriction, I can find no similar restriction on a grand jury. So if I go to a grand jury in Tarrant County, which is Fort Worth, and I say, I'm here to file complaints against these three guys. They committed this crime here and a similar crime in Dallas and one in Waco. Dallas and Henderson County are different counties from where this grand jury is, but that grand jury can hear all of those complaints because they are a statewide grand jury and they don't have a venue restriction. And I'm going to guarantee you it's the same way in New York. Now, the prosecutor and the judges and the police will all say, well, you have to file that in the county where it occurred. And I ask, okay, show me that in law. See, I am the master here, and the Constitution doesn't grant me any rights. I've got all the rights that exist except for those rights to which I have voluntarily agreed to restrict myself through my legislature. So if there's no law that says I cannot do a thing, then I can do that thing. Now, you, on the other hand, are a public official, and you may only do what you are specifically authorized to do. So you tend to consider me in that same perspective, that same light. Well, I'm not one of your group. I am the sovereign. Well, I don't like sovereign, but I'm the master here. I'm the one who has all the rights. I can do anything I want to. And if I want to go to grand jury, show me a law that says I can't, because if you try to restrict me, and you can't show me a law that says that I can't, that's official misconduct on your part. That's a crime on your part whenever a public official exerts or purports to exert an authority it does not expressly have, and in the process denies a citizen full and free access to an enjoyment right. That's a Class A misdemeanor in Texas. It's a Class A misdemeanor in the Fed and most every other state I've looked at. So let's back up and become the master. Everybody works for you. They forget that. And from my perspective, when one of my public officials steps across one of my legal lines, it is my duty to give notice to my grand jury. With that said, I never really want an official indicted unless he's done something really horrendous. I mostly file against public officials for following policy. Minor things. I had a judge direct a bailiff to arrest me. The bailiff put his hand on my arm. And I looked down and I said, I see you're wearing a pistol. And he said, yes, Mr. Kelton, I am. Tell me, Mr. Bailiff, is that pistol loaded? Yes, it is. Then the judge told him to back off because he knew I was setting him up. Sorry, Bubba, that bell's already being rung. The penal code says that if a public official commits simple assault, offensive touching or speech, as defined by 2201 Texas Penal Code, which is a Class C misdemeanor, and he is acting under the color or pretense of an official capacity while displaying a deadly weapon, that's a felony of the first degree, 20 to life. Our legislators thought that when a public official strapped a pistol on, that was a really, really big deal. But they forgot that. So the judge had the bailiff touch me, and I charged the judge with first-degree felony, aggravated assault. The grand jury has it right now. He's who has it to wait a month to see if they're going to end his career. Now, the likelihood of me getting an indictment over that, somewhere between little and none, but I don't want one. But I guarantee you, that judge's not going to pull that trash on me again. And it's so technical.
I want to hurt a few of them so that they complain to their peers about what was done to them, and maybe wake a few of the peers up. And
this is the thing. I told my district attorney. He's probably the only lawyer that I absolutely trust, and he's a prosecutor. He is exactly the kind of prosecutor you want to have. The guy is scrupulously honest. He agonizes over these cases. He doesn't railroad anybody. I really like this guy. So I filed a complaint with the Texas Ranger, and the Texas Ranger followed protocol and gave it to him. And I'd already talked to him, and he refused to touch it. I filed criminal conspiracy and obstruction of justice against the Ranger, criminal conspiracy against the director of the Department of Public Safety, and first-degree felony aggravated assault against my district judge, and took them to him. And I was going to give it to the bailiff, but I asked him, will you just give these to the grand jury? Then I won't have to, then you give these to the bailiff. And he said, sure, I'll do that. And I said, I want to thank you for protecting me from the bailiff. He said, Mr. Kelton, I was not protecting you from the bailiff. I was protecting the bailiff from you. Oops. Okay. But then I told him, I made my best argument for indictment in there. Now it's your job to get your behind in there and make darn well sure I don't get an indictment. He said, oh, you can count on that. And because I did not want an indictment. I don't want to end that judge's career for just being careless and let this anger get the better of him. Because I've been told that I have a way of putting peace officers and public officials over the edge. So I didn't want to ruin his career for that, but I don't want him doing this stuff I don't care if he does it to me, I'm not afraid of him, but I don't want him to do it to my wife or one of my kids. And the reason I filed against the Ranger was to force the DPS to change their protocols. I'd like to file against officials for following protocols. That way it's not personal, and I don't want him indicted, I just want him to change the policy. And it keeps you clean. I avoid controversy this way, and it makes you much, much more dangerous.
Well, yeah, when I got the tickets from...
Wait, hang on. We're about to go to break. Randy Kelton, Vet Pack Real Live Radio, calling number...
When teenagers don't get enough morning sunlight, they may have a tougher time sleeping at night, and that can cause lower grades. I'm Dr. Catherine Albrecht, and I'll tell you about the latest research into sunlight and night owl syndrome next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Do your kids have trouble getting to sleep? The cure could be a dose of morning sunshine. When teenagers don't get enough morning light, they're likely to go to bed later, get less sleep, and underperform in school. Scientists gave 8th graders special glasses to block so-called blue light. After 5 days, the students' evening onset of melatonin, the sleepy hormone, was delayed, and the kids fell asleep half an hour later than usual. So parents, open the blinds wide in the morning and help your kids soak up those rays. You can also buy light bulbs that mimic natural sunlight. It's the best way to help your kids shine. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Actually be kidding about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
You are listening to Rule of Law Radio with Randy Kelton, Vet Pack. We are talking with Joseph out of New York.
Hello, Joseph. Have you looked into grand juries at all?
No, I haven't. We talked about that in when I called in previously, and from what I understand, my access to the grand jury is through the prosecutor's office.
That's what they tell you. That's what they tell me. Okay. And in New York, it says the grand jury shall investigate into all crimes subject to indictment that come to their knowledge by whatever means. See, they always want to go through the prosecutor, because the prosecutor wants to exercise control over prosecutions. But that is exactly why the grand jury was put there, to prevent that. We have a case in Texas, Kennedy v. State, that puts this very well. In order to avoid the obvious evils of the accumulation of power in any one office, for the purpose of initiating a criminal complaint, a prosecuting attorney is not a credible person. There is nothing in Texas law that directs a complaint to a prosecuting attorney. Nothing. And I guarantee you there's nothing in New York law that directs a complaint to a prosecuting attorney. The only state that does that is Pennsylvania.
Okay. Well, then how would I access and inform a grand jury?
Okay.
Properly.
Glad you asked that. You make how many? You have 12 grand jurors or 23 in New York?
What's that?
How many grand jurors do you have in New York?
I don't know.
Some states, I think New York has 23. So you make up a complaint and you make up a package for each grand jury member. The first one you address to the foreman, and then the other one would be grand jury member 1, 2, 3, 4, and so on. And in the one addressed to the foreman, you put a cover letter. And that letter says that we sometimes have problems with prosecuting attorneys intercepting and secreting complaints from grand jurors. Therefore, will you initial this document and return it to me in the stamped self-addressed envelope so I can be sure you actually received it? Then you put that in a package, address it to the grand jury, and put the district attorney's address on the package. Then you send it to the address registered restricted. That means only the person named on it can sign for it. But this will come in, and the guy in the mailroom will just sign for it, and he'll give it to the prosecuting attorney, and he'll open it, and he'll trash it. And then when you don't get that letter back in, say, a week, then you make up another complaint. Except this one is a complaint against the district attorney for secreting documents from the grand jury. I'm sure you have a statute in New York for tampering with a government document.
Yes.
Okay. You charge him with tampering. The document you sent, when you mailed it to the grand jury, it became a government document. The prosecutor secreted that government document from the person or department it was directed to. That's a felony in Texas. So you charge the prosecutor with secreting the complaint from the grand jury. And, when they start telling you, well, you have to do this, and I always say the same thing. Show me that in law. If you can't show me it in law, did you just make that up? Well, that's how we've been doing things. I don't care how you've been doing things. You're a public servant. I'm not. I'm the master. You're the servant. I do what I want to, unless the law specifically forbids me to. So show me that. If you can't show me that law, I'm going to consider your act as an act of obstruction or witness tampering. You're trying to prevent me from giving witness to the grand jury of crime. I didn't write the code. I just read it. And if the prosecutor says anything to you that can in any way be construed as threatening, that gets witness tampering. Guys, it gets real deep here, real fast.
Sounds like fun, really.
Oh, it is. Have you gotten to see the chicken dance yet?
The chicken dance?
Chicken dance. Rex Hoskins, he's the chief of police in Decatur. Now, I've seen him do the chicken dance before, but this time I could hear him do the chicken dance. And that's where they start saying, well, Mr. Kelton, and they start shifting from one foot to another. I was following a chicken truck out of Atlanta one time, and they put the crates up in pyramids at the top, and one level down there was a chicken that got out. And he was standing there at the back, and they're doing 70 miles an hour down the road, and this chicken keeps looking up over that crate, and he's doing this little dance back and forth. And I followed him 70 miles waiting for that chicken to jump up into that airstream, and I was going to see a chicken plucking. It never occurred to me that he'd wind up going right through my windshield, but I was laughing too hard. And I'll never forget the look of that chicken shifting from one foot to the other, and you'll get to see just exactly that. But you don't get to laugh out loud right in front of them. But they can tell you're struggling to keep from it, and that makes them wonder what you're up to and makes it even worse for them.
I just smile at them a lot.
Yeah, it makes them crazy. Yeah, that's perfect.
When they make a mistake, my eyes get brighten up, and I get a big smile, and I just kind of nod, like I give them a kind of a silent thank you.
That's perfect. That's the attitude that makes the master of the servant so powerful. My goal in this whole show and all that I do, I have it very well defined. Because if you don't know where you're going, there's a good chance you'll wind up somewhere else. And it is my goal to place every judge in the country in a position such that when they step it behind the bench, look out at the bar, across the bar at the gallery, I want them wondering, which one of those scoundrels sitting out there waiting for me to render a ruling so he can run down to the grand jury and try to get me indicted? Yep. If we get him in that position, the vast majority of all the problems we're complaining about will simply go away. And you are exactly the reason I do this show. It's for guys like you.
I have had some success. The Alien Police, I can drive my van around all I like or travel in it. And I even allow one of my tenants who doesn't have a license to travel in it as he wishes. And they won't pull us over. All right, I
was pulled over in Austin, and the policeman asked me for my driver's license, proof of insurance. I gave him my Texas ID and proof of insurance. Well, they look exactly alike, except it has ID instead of DL, and they're really tiny numbers, so you got to look to tell. He came back and he said, "Well, Mr. Kelton, this is a Texas ID." I said, "Yes, as a matter of fact, it is. Do you have a driver's license?" I said, "Yes, I do, but I'm not using it right now." And he stepped back and looked at me and he said, "Mr. Kelton, are you one of those guys?" And I said, "Yes, I am. Here, have a nice day." Been there, done that, did not want to go back. And that's why I do the show. I'm not trying to get people out of in a position where they can commit crimes with impunity. That's not the purpose. It's the purpose of placing our public officials on notice that when you see Joseph in New York walk into the courthouse, he is the baddest motor scooter in the building. If you don't believe it, just step across one of his legal lines. He will show you.
Yeah.
This is how we get it fixed.
Okay, we're about to go.
Go ahead.
Okay. You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. Please call us at 512-646-1984. We'll be right back.
Easy.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. We've got a few more minutes left. We are on the air still with Joseph from New York.
Okay, Joseph. So what do you have planned for these guys?
Well, now for the trooper, he's a very honorable and decent guy. He's a real, he's a great guy to have in the community. So that when he wrote me up the tickets, I told him that he needed to argue something in New York called mandated reliance. And that's, mandated reliance upon a policy. And I told him, I'm going to use you as an instrument.
Okay. Normally in law, that's called good faith reliance on competent authority.
Mandated reliance is deemed to be a little bit stronger because it's a reliance that you're required of you to rely upon this policy. And, otherwise you lose your job. It's a little bit stronger than good faith reliance.
Yeah, I tell them all the time, well, Bubba, life is filled with little decisions. We all get to make some. Your turn. Are you going to follow policy and keep your job? Or are you going to follow law and not get prosecuted? Your call.
Prosecute him. I'm going to go after him both in his personal and professional capacity, but I wanted him to be able to get out of the personal capacity claim because I want the lawsuit to compel the troopers to change their policy. All right.
That is absolutely the perfect way to approach this.
Okay, so that's what I did with the trooper. Okay, I've argued the deputy prosecutor. I came and violated the second judge. I got to get around to came and violating the first judge. I had a bunch of other stuff on him from another case, and so I was going to do that too. Some of the things that I also hit Jacqueline with, I wanted to bring up, was additional possible offenses include but are not limited to official oppression, willful intent to injure another, malicious acts, RICO, and warring against the Constitution. And then I said, I believe that Petrucci and Asno are acting together in concert to intimidate me into conceding and waiving my right to challenge personam jurisdiction, waiving my right to preemptory challenges and defenses, and subjecting me to an adjudicatory process that fails to recognize the rules of criminal procedure law, civil procedure law, and judicial law. I believe that they are operating a criminal enterprise, subjecting the people to a foreign, that is a personal jurisdiction, as a quasi-corporate government operating entirely in the obligation of the Republican form of government guarantee, governing the public in violation of the doctrine of ultra vires. And I brought that up because I'm hitting him with a Coranto.
Okay, for those who don't know, ultra vires, that means outside the limits of a contract.
Outside the limits of their charter, correct. Outside the limits of their charter.
Their charter is their contract, and if you extend outside the limits of the contract, that's called ultra vires.
Yep. Exactly.
Okay, go ahead. I'll quit interrupting.
That was pretty much it. Then I, threw in some case law to, back up my claims and signed it and sent it off.
Okay, that sounds nicely constructed. So,
okay,
what do you expect to happen? Okay, have you filed the criminal accusations? This sounds like a preface to a civil or RICO suit.
This is correct.
Okay, have you looked at the criminal side?
I have just begun to.
After doing this for all of this time, it's become clear to me that is absolutely the first place to go. When you start filing criminal charges against them, everybody's going to step in line to try to shield them. They're all going to squeeze up behind this thin blue line. And this goes to politics. So you go in there and the judge pulls a little song and dances seltzer down your pants. So you call the 911 or ask the bailiff to arrest him. That is so much fun. Are you familiar with the tar baby?
Yep. Well, yeah.
Yeah, I got this little tar baby. And I say, Mr. Bailiff, come over here. I got this tar baby. You want to touch it? Here, go ahead, touch it. I want you to arrest the judge. Why can't you arrest the judge? Sure you can. Just throw the cuffs on him and drag him off to jail. Heck, you don't have far to go. Besides, it'll be fun. You stand around here doing nothing all day. That's what I told the one in Montgomery County. And he said, well, I can't arrest the judge. I said, well, life is filled with little decisions. We all get to make some. Your turn. Are you going to perform your duty, keep peace in the courtroom? Or are you going to shield that judge from prosecution in violation of 3805 Penal Code? Your call. And when he refuses, I did this in Lake Worth, Texas. I asked to see some records. They gave me a little problem. They finally brought me the records. And then the judge came over and said, Mr. Kelton, you can't look at those records. You are a security risk. Oh, I'm a security risk. And I've got this record open. And I can't look at these records. No, you can't. So I closed it, pushed it across the table. And by then a bailiff had kind of sidled up behind the glass. I said, Mr. Bailiff, did you hear that? Yes, Mr. Kelton, I did. Arrest that woman. Why can't I arrest her? This is her court. Oh, no, you are mistaken. This is my court. And I very generously allow her to administer it in accordance with my law. And she just broke one of them in your sight and in your presence under 14.06 Code of Criminal Procedure. Arrest her. Well, I can't arrest the judge. Mr. Kelton, I have to be the bailiff in this court. Let me take you down to my boss. So he takes me down to the elected constable. And he said, what can I do for you? I need you to arrest him. And the bailiff had this unbelieving look on his face. Why would I arrest him? Because he's a chicken. What? Because he's a chicken? Yeah, I wouldn't take his chicken suit off and arrest the judge. And he said, well, we're constables and we don't take complaints. Are you a certified police officer? State of Texas? Yes, I am. Then I don't care what your policy is. You're a certified police officer, and I've made it known to you that crimes have been committed under 2.13 Code of Criminal Procedure. You have a duty to take my complaint, submit it to some magistrate. Well, we don't take complaints. Okay, if that's your call. Oh, where's the sheriff's department? Don't they have a little office around here? Yes, right across the street. Okay, see you guys later. While I'm at the sheriff's department waiting for them to get me an officer to arrest the constable comes over. And he said, Mr. Kelton, if you want me to, I'll take your complaint to the prosecuting attorney. Oh, no, don't do that. I'll get to the prosecuting attorney, but I didn't get everybody to touch my tar baby yet. He said, you what? See, I got this little invisible tar baby. The judge touched it, and the bailiff touched it, and you touched it. Now I want to get the sheriff to touch it. He just ducked his head, shook his head. But he knows he's stuck. And they know I'm setting them up. And that is the thing that makes them the most afraid. And that's what you're doing to them, Joseph. When they screw up and you smile at them and don't get agitated, they're thinking, this chump is setting me up. Have you seen that in them?
Yes. Yeah, right now I'm just looking for, to get as many accessories after the fact as I can. The more the merrier.
Yeah.
In that too.
Yeah. When you start with the criminal complaints, everybody's going to step in line to protect them. And then when you go after that one, he's going to go back down the line and say, what is going on here? What did you guys get me into?
Yes.
Everything is political, and all politics is local. And criminal complaints, while we almost never get anybody before a grand jury, or certainly almost never get anybody indicted, what we do is create a lot of politics. I almost got all the highest judges in Texas indicted one time. The 15 judges of the Court of Criminal Appeals. We have 2 high courts, Supreme for civil, criminal appeals for criminal. I got them all put in front of a grand jury. And I thought it was my eloquent oratory and all the pressure I put on these judges and prosecutors. Turned out it had nothing to do with any of that. 25-year prosecutor, Ron Earl, not running for office again. He's a Democrat. All 15 of these judges are Republicans. He took my complaint and used it for as cannon fodder to try to take those guys out with him. And that's what they're most afraid of. And the higher up the line you go, the more afraid of that they are. You're creating cannon fodder for their opponents to use against them, and that's what terrifies them. But on the other hand, that's what makes us so powerful. So try the criminal side. You will love it. You will definitely get to see the chicken dance. And if you haven't called 911 on a judge yet, you just haven't lived. I did that to a judge 3 times in his courtroom one day in Temple, Texas. Oh, that was so much fun. Okay, Joseph, keep up the good work. You are absolutely the reason I do this show. And the next time I come to New York, what part of the state are you in?
I'm in the middle of the state. I'm just a little bit east of Utica, New York.
Oh, Utica. East of Utica. You know where Middleville is?
Oh, I very much, yep, I do.
If you get to Middleville, there's a school there. Knock on the door. Say hello to Pastor Master, or Master Pastor, Pastor Massad. Very good friend of mine. I do a show on his network every week. Okay, we are out of time. Randy Kelton, Vet Pack, Real Law Radio. We'll be back next Thursday for our 2-hour show, and back again Friday. Make sure you listen. Thank you for listening. Good night.